All rise. The Court of Appeals, Division 1 is now in session.
Good morning. Be seated. Now is the time set. It may take me a minute to get this out because of the particular case, but now is the time set for oral argument in Maria Rosas, Maria Castillo, and is it Wachtell? Korea? What?
Sochi.
Okay, Xochitl is Sochi? Thank you, Korea. Those are cause numbers. Hang on. I guess it's consolidated as 1CA UB 17-0416. Does that sound familiar? All right, thank you. For everybody's information, these proceedings are being both audio and video recorded today. I believe, are we back up?
Yeah. Is it not the consolidated number?
It's not the one I've got. For the record, we've got it noticed as 1CA UB 170385, Rosas versus Ades/Chicanos is the way it's listed. And that will hopefully watch anybody that is watching this, if we're being recorded today. If in fact it's working at this point, you get the chance to critique yourself in a couple of weeks. I think you probably all know how that works, so good luck to you. Counsel, each side today is going to be entitled to the normal 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And for the appellant's benefit, if you wish to save any portion of that time for your rebuttal, please let us know. We will try not to take all of it. Can't make any promises. Ultimately, the reserving of the time is up to you. We've reviewed the briefs and conference the case this morning, so we are well aware of the facts and issues attendant to this argument. You might want to keep that in mind in addressing the court this morning. Counsel, when you come to the podium, I would ask that each of you state your name and who you represent. And with that, the appellant can begin.
Good morning, and may it please the court. My name is Stephen Biggs. I represent Maria Rosas, Maria Castillo, Alicia Solorzano, and Sochi Korea, who are the unemployment insurance benefit applicants in this case and the appellants. At issue in this appeal is the interpretation of the between terms denial of benefits rule in ARS section 23-750E5 as it applies to employees of nonprofit Head Start programs. In the administrative proceedings, the Department of Economic Security's Appeals Board held that the application of this statute is limited to wages that an employee...
First, granted benefits.
Correct. So the deputy granted benefits, these cases all have somewhat of a tortured procedural history. The deputy granted benefits, the appeal tribunal originally affirmed but held no hearing, so the appeals board vacated, remanded, and then the appeals tribunal with a new ALJ held a hearing at which the issues were whether the employees could use the wages from their employment with Chicanos por la Casa to establish their monetary eligibility for unemployment insurance benefits. The appeal tribunal found that they could not use the wages, any of the wages from that employer.
And when you say any of the wages, you're saying as to each of the four, none of them were able to claim?
Correct. None of the four were able to claim any of their wages towards their establishment of monetary eligibility for unemployment insurance benefits.
Even given consideration to the different jobs they performed?
Even given consideration to those differences. Basically, what the appeals tribunal and appeals board, they both had the same holding, did was they incorrectly interpreted the statute. They left out part of the statute.
But the theory is that this child care agency provides services under an agreement with school districts that the school district is otherwise obliged to provide. And even though that's only part of what the child care place does, that basically made all of the claimants ineligible in toto.
That was a theory that doesn't work under the statute.
That was the theory, isn't it?
I think that was the theory. It's difficult because neither the Appeal Tribunal nor the Appeals Board actually really gave any consideration to the specific tasks that were being performed by the 4 employees we have here.
Was the theory limited solely then to the fact that Chicanos por la Casa was contracted to a school under a memorandum of understanding, and that anybody they sent over then was covered under that memorandum?
No, I think it was broader than that. I read the decision as any employee of a Head Start program that provides services to or on behalf of an educational institution cannot use any of their wages to establish monetary eligibility for unemployment insurance benefits between academic years and terms. I think if you look at, I'll read to you particularly one of the passages that's the same in all of these cases in the Appeals Board decision that I think reflects that. The Appeals Board in all the decisions said, the school employees' eligibility provisions of ARS Section 12750E apply to Head Start program employees if the Head Start program provides services to or on behalf of an educational institution, and if the employee has a contract or reasonable assurance of reemployment by the Head Start program in the ensuing academic year or term. So when you look at that, that really doesn't matter what tasks the Head Start employee performs. It's a per se rule, essentially, that if you're an employee of a Head Start program and that Head Start program has a memorandum of understanding with a school district, which they all do, by the way, then you cannot collect unemployment insurance benefits between academic years or terms.
Regardless of whether you're in a classroom or in a cafeteria or a bookkeeper back at the Chicanos por la Casa Center, Business Center?
Correct. The way they've stated their holding, that would apply. Now, I think it's important to keep in mind that all the employees here, they were never performing any services at the school district. So Chicanos por la Casa has these child care facilities where they run Head Start programs. The school district has its own facilities that are separate, where the school district provides special education services under the MOUs for children with disabilities. Now, there are some things that the Chicanos por la Casa Head Start program does under the Memorandum of Understanding to assist. I group them into 4 general categories. The first is that they screen. So they screen all enrolled preschool children to see if they're at risk for having developmental disabilities and may need special educational services.
But they do that, I'm sorry, but they do that at CPLC?
Correct. And there's no evidence in the record that any of the applicants here did that or participated in that screening process.
That screening is, I mean, there are children at this facility. Is it one facility?
So each of these employees worked at different facilities. I believe Maria Rosas and Maria Castillo may have worked at the same facility. There was more than one in Somerton. So they may have worked at the same one, but the other ones...
At least one of your clients is an infant and toddlers person, right?
2 of them are teachers of infants and toddlers.
And so they're not involved in these MOUs, right?
Correct. They teach the children up to age 3. And under federal law, these infant and toddler programs only service children up to 3. And I acknowledge there is ambiguity in the record on this issue. Part of it's due to translation and, frankly, interpretation errors, or transcription and interpretation errors. But there is ambiguity that there may have been some 3-year-olds at some time transitioning between the infant and toddler class to the preschool classes and the 2 applicants that applies to is Maria Rosas and Soshi Korea.
But assume that's true. I mean, there's some. Would that result in a complete denial of benefits, or could there still be an allocation saying, "Oh, you worked"? I mean, maybe this portion of your wages might not, or maybe 5% of your wages would be attributable to what you did on behalf of on the screening purposes or on behalf of the 3-year-olds, but the rest was not covered. Would that?
That's exactly correct. There has to be an allocation under the statute, because the way that unemployment benefits work is that you have to establish monetary eligibility by showing you met a wage threshold. And this statute, this denial of benefits between terms statute, seeks to distinguish which services, so what wages for which services you can't use to establish your monetary eligibility. So if a Head Start program employee is teaching infants and toddlers and doing nothing under the MOU, all of the wages for that can be used to establish monetary eligibility for unemployment insurance benefits.
But not under the school.
Not under the school. So if they were a school employee, that would be different. The statute's very clear that school employees, basically anything a school employee does, they can't use to establish eligibility for unemployment insurance benefits between academic years and terms or the other breaks that are referenced in the statute. But under the plain language, it's different for employees of nonprofit institutions whose employer simply provides services to or on behalf of educational institutions. And if you look at the development of the statute, that's clear. That was added later. So originally you had this between terms denial of benefits provision that under federal law was instituted first just for school employees. Then it was extended to employees of educational services agencies who provide services in an educational institution. And then in 1983, the federal government said you can extend it also, optionally, to employees of nonprofit organizations, and the statute's clear. Who performed these services, meaning services in an instructional, research, principal, administrative, or other capacity for an educational institution, while in the employ of an entity that provides these services to or on behalf of an educational institution. I mean, if you break that statute apart into its grammatical pieces, that last part, who performed these services, it's an adjective clause, and it's a restrictive clause. It's necessary to the meaning of the sentence, and it modifies the noun individual. So for an individual to be subject to this denial of benefits provision, she must have performed services. She must have performed the services. She can't have performed other services that were not to or on behalf of the educational institution. It's only about what services she performed for her employer that were provided to or on behalf of an educational institution. And then if you look at before that, it says benefits are not payable on the basis of the services specified. That's where you get that it's benefits aren't payable on the basis of those services means you can't use the wages earned from performing those services to establish your monetary eligibility. But there's nothing in the statute that would preclude someone from using the wages they earned working for the Head Start program that weren't provided to or on behalf of an educational institution to establish monetary eligibility. If you interpret it that way, it actually violates the equal treatment requirement. And the equal treatment requirement was where Congress came in and said, look, you have to treat employees of nonprofit entities the same as employees of any other employer that pays unemployment insurance taxes and whose employees can get unemployment insurance benefits. That was the idea behind the equal treatment requirement, because before, employees of nonprofit entities, before the 1970s, were not eligible to receive unemployment insurance benefits, period. So the federal government sought to have the states put those employees on an equal playing field with all other employees, and then created very specific exceptions, which Congress instructed that you construe narrowly. And our own case on this state says that we are to construe exceptions to unemployment benefits narrowly when they deny benefits and broadly to grant benefits. You take that together, the natural reading of the statute and the only really permissible interpretation of it is that an employee of a Head Start program, and I know this is somewhat confusing and convoluted, but these are the wages that an employee of a Head Start program can't use to establish their monetary eligibility. It's wages they earned for services performed really in any capacity for an educational institution while they were employed by a Head Start program, and that Head Start program provided those services to or on behalf of the educational institution, and the employee had a reasonable assurance of performing those services in the next academic year or term. It's a narrow exception, and a lot of things have to be met. And here, the department did not require the employees to meet all the requirement that they had to perform the services. And those services would be services that were provided to or on behalf of an educational institution.
In the order that Judge Johnson issued granting this appeal, she basically mentioned two broad categories for discussion. One of them is that there's a certain population in these centers of disabled students that are presumably school districts are required to provide certain services for them, and then also to address the services that each claimant provided. Now, you have two of your clients, one's a cook and one's a cook's assistant, is that
Yes.
what I understand? So if we look at, let's just say that there is a 10% disabled population among these centers. So a cook or cook's aide presumably is providing services to all of the persons there, all of the children. So your position would be that the most that would be excluded as far as eligible wages would be whatever this percentage would be of disabled students. I assume a cook or cafeteria worker or cook's assistant is providing services to that cohort also.
No, I would disagree with that. I would say that for the cook and cook assistant, none of the service they provided were services that the Head Start program agreed to provide to or on behalf of the educational institution. Food services is not covered at all in the MOUs, and it is the meals and snacks are something that the Head Start program under the federal Head Start regulations was required to provide to those students. Had nothing to do with special education services that were being provided under the MOUs. So even if there were special ed kids who were getting fed, those services were not being provided to or on behalf of the educational institution. They were being provided on the time that those kids were in the Head Start program. I do want to reserve some time for rebuttal, but I'm happy to continue answering questions.
Yeah, just one question. To what extent is it relevant here that the department issued a memo or a broadcast, if it was referred to as a broadcast, I believe, broadcast 153, if I remember correctly, saying that the Head Start was not providing educational services, and then the board apparently rejected that?
So I could not find a copy of that bulletin, but I know what you're referring to, Your Honor.
It's referred to in the
correct. It's in the
board's
record.
decision.
So I don't think that has any import because under the federal interpretations of the federal law that allows the state to institute this denial of benefits rule, the federal interpretations have basically said that Head Start programs are not educational institutions unless they are run by a school district, a board of a school district, and the employees are employees of the school district, essentially. So I think that broadcast was mixing issues. I think that broadcast was looking at, okay, well, these Head Start programs are not educational institutions, which is correct, and the appeals board in one of the decisions specifically said they're not educational institutions. And so, to me, that's beside the point because the issue is whether the services that these employees were performing were services provided to or on behalf of the educational institutions. And normal Head Start program services don't fit that category. Only those services covered by the MOU that the Head Start program was performing for the school district for these preschool children in need of special education services.
Now, we have more cases, or have had more cases than these. And am I correct that apparently what brought these applications on was communication from the Labor Department telling people that they were eligible for unemployment?
Yes, for years, these employees and others of their coworkers have been receiving unemployment insurance benefits for these same summer breaks. It was just suddenly the employer decided to challenge that, and then we got these rulings. But for years, they had been told, you can go and collect unemployment insurance benefits in this context. And I think it's because the statute allows them to.
They were told by the Labor Department? Or
It's unclear from the record who actually told them, whether it was somebody at Chicanos por la Casa.
Some of the claimants in the record have said, they told me I could get benefits.
Yeah.
Somebody told me.
And it wasn't clear to me whether it was ADES or whether it was someone at Chicanos por la Casa. And I can't figure that out from the record, and I apologize. I don't have the answer to that one. If I could reserve the remainder of my time. Thank you.
Counsel.
May it please the Court. My name is Joanne Falgett, and I'm representing the Arizona Department of Economic Security in this matter. This case can and should be quite easily disposed of. Under Arizona Revised Statute Section 41-1993B, quote, an issue may not be raised on appeal that has not been raised in the petition for review before the appeals board. Certainly, this issue, whether these specific employees provided certain specific services to or on behalf of the school district, was not raised anywhere in the record below. There was a deputy determination, an initial ALJ determination, an initial appeal to the board, which remanded for additional fact-finding, a new ALJ determination, and a subsequent appeal to the board, and nowhere in any of that did these claimants raise this issue. The allocation issue about allocating some percentage of wages to determine unemployment eligibility wasn't even raised until the reply brief in the case on appeal. And I submit that that is simply unacceptable. Under Mungia versus Department of Economic Security, that case stated that an appellee was, quote, statutorily prohibited from raising an issue for the first time on appeal. Prebula versus Arizona Department of Economic Security, that's 138 Arizona 26, stated that the court was, quote, statutorily prohibited, end quote, from addressing a claim that was not raised in a request for review to the
Counsel,
board.
putting aside the reply brief issue, to what extent isn't this just challenging the sufficiency of the evidence? And in that regard, I mean, you're aware, we receive hundreds of these every year, and we have these applications for appeal, and I believe I could speak for the court in saying we give those a liberal interpretation, whether that's in reviewing those to see if there's any viable claim, if you will, any viable argument that would justify granting that application for appeal, and the vast majority they're denied. So, but to what extent, I understand what the statute says, but to what extent can we, because you're talking about knocking out a whole bunch of those if we were to strictly apply that in every case. Where do we find a balance there? Because
And again,
help me out
to the
there.
extent that they're arguing that the evidence is insufficient to support something, and they never raised that factual issue, never submitted any evidence themselves about it, and the evidence that is in the record does support a conclusion that these claimants were providing services to or on behalf of the school district. And so let me talk for a minute about some of the things that might have been submitted had they raised this issue below. Under the Individuals with Disabilities Act, in Education Act, it requires that the school district provide a free, appropriate public education for children with disabilities ages 3 to 21, but it also requires the state to identify children with disabilities under the child find provisions. And that is, as the HR administrator and all four of the employees testified, that is something that this program did at CPLC. Additionally, it requires that children with disabilities must be educated with children who are not disabled to the maximum extent if possible in the, quote, least restrictive environment. That's 20 U.S.C. Section 1412A5. The children are to be provided special classes or separate schooling only if education in regular classes with use of supplementary aids and services cannot be achieved satisfactorily, end quote. So to try to draw a distinction that only 10% of the children had disabilities and therefore possibly only 10% of their time was spent providing services to the school district is simply incorrect. In order to provide the least restrictive environment and provide an education for children with disabilities, along with children who are not disabled, one must also provide that service to children who are not disabled. Additionally, Part B of under the IDEA provides for preschool grants. Grants can be used to provide special education and related services, quote, to 2-year-old children with disabilities who will turn 3 during the school year. And that was Section 1419A. Section 1419F says that states can use funds, quote, for support services which may benefit children with disabilities younger than 3 or older than 5, as long as those services also benefit children with disabilities ages 3 through 5. And then we also have Part C of the IDEA, which covers children from birth through age 2, offering early intervention services, and provides for allowable uses of funds, such as under Section 1438(1), direct early intervention services for infants and toddlers with disabilities that are not otherwise funded through public or private sources, providing the free appropriate public education for children with disabilities from their 3rd birthday to the beginning of the following school year, collaborative efforts related to at-risk infants and toddlers for the purpose of identifying and evaluating at-risk infants and toddlers, making referrals of infants and toddlers identified and evaluated under subsection A, and conducting periodic follow-up on each referral. All of these items are things that were provided for in those memorandums of understanding, those MOUs.
Or they were incorporated by reference? They were incorporated by reference?
I don't know whether they were...
they're impliedly incorporated.
I'm saying that all of those services are the things that the MOUs provided for. I don't think that they needed to cite... They did mention providing services under the IDEA. They didn't cite the specific statutory section for each one of those services, but that wouldn't be necessary in an MOU if, in fact, what they're doing is providing services that the school district is otherwise required to provide. I would also point out that the U.S. Department of Agriculture's non-discrimination regulation, 7 CFR 15B, as well as various regulations governing the National School Lunch Program, require accommodations for children who cannot eat school meals because of their disabilities. And I can't remember which of the food service workers testified that indeed part of what she did was provide special meals for children who had a medical requirement that they not eat the regular school lunch. They eat the nutritional meals that are specified under their IEP or by the doctor's note.
So you're saying that because the MOUs provided that the employer would provide services under the IDEA, that is saying that the MOUs encompassed everything that's in the IDEA?
I'm not saying it comes to everything, but those MOUs listed a lot of things that the CPLC was going to provide and do to assist the school districts in meeting their obligations under the IDEA.
All those things you just told us about?
All those things I just told you about are also listed in the MOUs. So the MOUs, for example, and this is Rosas Exhibit 13, it says, page 1, the intent is to ensure free, appropriate public education in the least restrictive environment for special needs children under the IDEA. Program mandates are to identify children with disabilities through child find efforts, which include a screening process. Program mandates are also to ensure special education services provided in accordance with IDEA, to place, quote, place preschool kids with disabilities in the least restrictive environment, parentheses LRE, with an opportunity to interact with peers who do not have a disability to the maximum extent as appropriate, end quote. So even if they're also providing services to non-disabled children of younger ages, the same age, older ages, whatever, they are still providing services to the school district in accordance with its obligations under the IDEA as the MOUs identified. And all of these are things that could have been resolved at the board level to nail down the fact that these people were providing services to or on behalf of the school district pursuant to its obligations under the IDEA. But they didn't raise that issue. All they argued was, oh, the facts didn't support it, or sort of vaguely, you know, I disagree with the ruling. And so I submit that because it was so obvious that these instructional personnel and these food service workers under that unemployment, hold on, let me get the name of it for you exactly, under the UIPL 41-83 from the U.S. Department of Labor, the Unemployment Insurance Program Letter 41-83 clearly stated that personnel such as crossing guards, bus drivers, and cafeteria workers are examples of services that can be considered to be, quote, provided to an educational institution under the unemployment between terms exclusion. So I think because it was so clear that the people were either providing instructional services or providing food services, there was no question. It's not a case where you have an accountant for CPLC as a whole that is being denied unemployment benefits. These are people...
What if it was a bookkeeper that's just responsible for monitoring or keeping and tracking all time solely for the 10-month period, 9-month, solely for the period in which they're working.
That's possible. And these things, UIPL 41-97 states that whether services are, quote, provided to or performed on behalf, end quote, of an educational institution depends on the facts present in each individual case. It has to be a case-by-case determination. I don't know the answer to your bookkeeper question, but I do know the answer.
Did the board here decide it on any facts, or did they decide as a legal proposition that if you're doing work for Head Start, you're precluded as a matter of law?
The facts demonstrated that these people were either providing instructional services or food services, which are encompassed within the USDOL UIPL 41-83 and 41-97. So the only real issue was whether they were doing so to or on behalf of the school district, which is the issue that the board addressed.
Counsel, I thought it was pretty clear listening to appellant's argument that they weren't working pursuant to the MOU. I asked that question, and I believe the answer was no, they weren't working under the MOU.
Right. And so here's sort of a bifurcated analysis. And as he brings up, yes, the services that the employees provide do need to be provided to or on behalf of the school district or the school institution, but also they have to be provided, they need to be providing qualifying services, just to shorten that. So I think because it was so clear that the services at issue were qualifying services, in other words, they were instructional people or food service workers, all of which are identified as things that qualify for services that can be offered to or on behalf of a school district, the board narrowed the issues to the only two things that appeared to have been disputed, which is whether they were provided to or on behalf of the school district and whether they had a reasonable expectation of employment in the following school year. They have not challenged on appeal whether there was that reasonable expectation of continued employment in the following school year. The only thing that they've arguably challenged is whether the services were provided to or on behalf of the school district.
So is it fair to say that the teachers worked for CPLC, CPLC worked under their agreement with the school district, which was reflected through the terms of the MOU?
Right. And
so indirectly, they were working under the MOU.
Right, indirectly, sure. And all of them did testify that they were aware that CPLC provided services for the school district in connection with these disabled children, and that they had the obligation to identify children who might need special education services and refer them to the school district. So, they were aware of this working relationship with the school district, and they knew that they were providing services that, the school district otherwise would provide. The children were at CPLC for the purpose, from what I can gather from reading the MOUs and the IDEA, for the purpose of providing that least restrictive environment interaction with non-disabled children. To the extent that they needed additional special education services, they were actually transported from CPLC over to the school district to have whatever special instruction they might need, and then brought back to CPLC to spend the remainder of their day in the least restrictive environment classroom with non-disabled children. So that entire service is something that CPLC was providing for or on behalf of the school district, as reflected in the MOUs. The MOU was admitted as part of the evidence. They were all substantially the same. There may be a couple of differences in wording, but essentially they're all the same. And again, that's Rosas' Exhibit 13. One of the things it provides is that CPLC would have the responsibility to actively recruit, enroll, and serve eligible children with disabilities ages 3 to 5. So one of the ways that they did that was by enrolling children younger than that, evaluating them, determining whether they might be appropriate for services, and referring them to the school district for additional testing so that when they are 3, they will be ready. Again, part of that child find effort to identify children who are going to need special education services.
And where do you put the employees who are seeking benefits that were providing services to infants through 2 years old? Where do they fit in the MOUs? Again,
part of that child find, and each of the teachers that was providing services for the infants and toddlers. In fact, I believe it was Ms. Rosas testified that she was, quote, now working with 3-year-olds. And I believe, and I forget which other one, let me look at my notes, the other instructional person, let me get this right, sorry, Ms. Courier, also testified that she worked she's an infant toddler teacher for children ages 0 to 3, but that she admitted that in her position she was providing services that were required of the school district under the IDEA, and that was at page 12 of her transcript, which is the...
Were those services for infants and up to 2 through 2 were IDEA qualified? They were part of the MOU. Is that right?
That would be my understanding under the child find provisions of the IDEA, yes, and the obligation to identify children who need the services, and also as part of the obligation to provide a classroom environment with non-disabled children. So to the extent those children don't have disabilities and are not, in fact, needing special education services, nevertheless, they're entitled to have that classroom environment with non-disabled children. So essentially, all of the services that CPLC was providing was to or on behalf of the school district. Ms. Suarez, the assistant HR director, testified that they, as closely as possible, tracked their schedules to follow the school district schedules, to have the same vacations and so forth, because those children needed to be able to access the special education services through the school. They needed to be able to coordinate with the school district personnel in order to do what they're required to do under the MOU.
Are those services able to be provided year-round? Or is it a function of the school year that controls their working period?
That's kind of two questions. Are they able to be provided year-round? I don't really know the answer to that. Nobody raised that below. But the facts demonstrate that, in fact, they only provided whatever services they provided during the school district. They were open the same hours, the same days as the school district. They tracked their vacations with the school district, including the summer vacations and winter vacations. So, again, because this issue wasn't raised, it wasn't fully fleshed out below, because this issue about allocation of part of the wages to maintain eligibility wasn't raised, again, the department hasn't really had an adequate opportunity to address that, but I would submit that regardless of whether that's a valid theory or not, in fact, 100% of the time that these people spent providing services working for CPLC was provided to or on behalf of the school district. And again, this court really should dismiss the entire case under ARS Section 41-1993B because they didn't raise any of these issues before the appeals board. But even if the court decides to go forward and address these issues, there is sufficient evidence in the record, Judge Brown, to support what the...
I'm a little perplexed. If none of the stuff was raised below, then where did our panel get the idea that these issues were present?
I don't know.
They had to get it from the record, right?
I don't know.
Here's Judge Johnson's order. The record contains memoranda of understanding between the employer and one or more school districts, etc. She describes the memoranda of understanding, so those are clearly in the record. Then she addressed the position taken by DES and eventually discussed the rulings from the appeals below. So all of this was in the record, wasn't it? I mean, Judge Johnson didn't just make it up.
Well, certainly there is sufficient evidence to support what the board did, both in finding that under the MOU, CPLC was providing services to or on behalf of the district. And again, it was never questioned that those particular employees were providing those services. So it's not like we have a situation where there's an accountant or a landscaper or somebody that provides services for CPLC in general, but is not involved in the day-to-day provision of services for the children in the facility. It was clear from the record that that's exactly what these employees did. They provided services for the children at the CPLC facility, which was providing services pursuant to the MOU. So I don't, perhaps they raised it in their petitions for review, or at least enough that Judge Johnson thought that they raised it in their petition for review, but I submit that a thorough review of the underlying record will reveal that nowhere did these employees argue that, you know, I might be an employee of CPLC, but I'm not providing services to or on behalf of the district personally.
It appears that 3 of the 4 petitions for review were in Spanish, and only 2 of those were translated. So I don't know that she got that from the petitions for review. But it looks like this order was based on that panel's review of the record and a conclusion that what was in the record supported our further inquiries that we're required to undertake today.
To what extent is it reasonable to ask a person who presumably don't speak English to who they're working for, or if they're working under an MOU? I mean, that seems like quite a stretch.
They had a translator, and they asked them specifically about whether they knew
The legalities. I mean, look at the briefing on that. I mean, we're having oral argument on a fairly sophisticated issue here that's not easily grasped. Given the federal regulations, the state, less than clear state law on this issue, in my view, it just seems quite confusing.
I see that my time is up. Would you like me to try to answer, or?
No, that's fine.
Okay, thank you, Your Honor.
Counsel, can you start with Judge Thompson's question about the content of the record?
Yes. So this issue wasn't waived. So if you look at the record, how it came up is the employees made a prima facie case of eligibility for unemployment insurance benefits. The employer then appealed. And the issue before the appeal tribunal was, can the claimant use educational wage credits to establish monetary eligibility for benefits? It's really the same issue we're addressing right now. The employees made a layman's argument that they were eligible for unemployment benefits because they didn't provide services for the school districts. They were speaking in Spanish through interpreters. This is difficult legal issues. They did the best they could to make that layman's argument. We weren't providing services to the school district. Why are you denying us unemployment insurance benefits? The tribunal then decided that the statute applied and looked at the statute and said it applied, and that, because the employer, solely the employer, was providing services to on behalf of an educational institution, the statute applied. The appeals board decided that same issue and came to the same conclusion. On appeal, we're simply arguing about whether the statute was correctly interpreted, an issue of law that this court can address really regardless under its case law of whether it was raised below or not. I think it was raised below to the best these individuals could do it. And that's why the panel that granted the application for appeal granted it. There was clearly a basis in the record to come to the conclusion that this issue needed to be addressed. And really the briefing addresses the issue to the best of my ability that the panel asked be addressed after I researched the case law. So I don't think the issue is waived. I think the Hildy case helps you with that. It makes it clear that the legislature, when it has rules like this, it couldn't possibly intend that people who aren't represented by counsel who could somehow make the complex legal arguments. It's just whether it was fairly presented, and I think it was here.
How do you respond to Ms. Valgott's assertion that actually these centers were providing a lot of functions on behalf of the school districts? And she gave us a whole list that are, she says, are encompassed under the IDEA and then under the MOUs.
I think a lot of those things aren't found anywhere in the MOUs. There's nothing about food services in the MOUs. I think what's becoming confusing here is the department here on appeal is throwing in a bunch of federal regulations, some of which have nothing to do with the IDEA, and saying, well, if federal law says that a Head Start program should do this, then it must be providing these services to or on behalf of an educational institution, which simply isn't the case. The MOUs clearly state the responsibilities of each party, of the educational institution and the responsibilities of the Head Start program. And if you look through those, and we did in the brief, none of the applicants here did any of those. Really, and I'll try to do this in 20 seconds, if this had been done the proper way and the employer wanted to say some of these or all these wages should have been excluded, the employer should have come in on its appeal and identified these are the services that they provided to or on behalf of the school districts. And these are their wages they got for these service. Exclude these wages from the calculation for monetary eligibility.
But again, just briefly, your position is that as to your 4 clients, none of them were involved in this screening function.
There's no evidence in the record that they were. And I have no knowledge that they were, but it really matters what's in the record.
Not with regard to the, if that's the right number, 10% of the population of children in these centers that were disabled students.
Well, so the MOU specifically says it applies to preschool age children. So 10% of their preschool enrollment have to be students with disabilities entitled to special education. And none of these people worked in the preschool classes.
Okay. So those were separate
Yes, there's a separate infant toddler class and there's a separate preschool class. And that's under Head Start guidelines. You have those two separate types of classes. Thank you.
Counsel, thank you. I think there's some reference made to the potential complexity of the issues in this case. I think that was kind of grossly understated. I thank you for your willingness to ask our answer our questions today. For the time you spent with us, I think we do have a better grasp on it now than I certainly know I did before. Thank you for your time. We're going to take the matter under advisement at this time, and we'll issue a decision in due course. And with that, we're adjourned. Thank you.